Thanks very much. Please let me know if you can't hear me. I'm guilty of always having the microphone too far away from me. I really appreciate the chance to be with you today. It's a great group of women business leaders, and it's a real privilege to be here. And it was a great segue into my remarks, hearing about another successful business opening in our community. So thank you for sharing your experiences with us. Again, it was a perfect inroads, because what I've done today is I really wanted us to have the opportunity to talk about some common issues that I see arising again and again with small business owners as we become, I don't want to say victims, but people who are faced with the joy and the downside of our own successes. And so I'd like just to talk with you today a little bit about some common things that I see that people have challenges with or catch people by surprise as they're running their small businesses, and give you some insight about some federal law and some New Hampshire and Vermont state law. And I deliberately didn't do a PowerPoint today because as I started to think about what I wanted to talk with you about, and by all means, feel free to be asking questions or sharing insights with each other as we talk about this today, I realized that what I wanted to do more than anything was to give you kind of a toolkit, if you will, to take back to your businesses and just to have as a resource in the next year as you're thinking about issues that come up. So this discussion is really to try to give you a sense of maybe some issues that ought to be raising some red flags for you as you're running your businesses. And so what I did want to do is actually work our way, kind of just give you the overview and go through the materials a little bit so you know what you have, and hopefully it can be of help to you going forward. And I should say, give you the overview of what they are. They're a good starting point as to some of these thorny little issues that we find ourselves facing. And so the point would be, to look at it, to say, okay, I remember this being an issue, a problem. It seems like maybe I'm going through this now myself. Where is a good place for me to look to start thinking about what I need to do? So hopefully it's of help. I really kind of divided things down into a few different categories to talk about. And probably the most common challenges we see when we work with our clients and our colleagues is that we see a lot of wage and hour issues. Not surprisingly, everybody has these issues. So those are some very common traps for the unwary, no matter what the size of your business is. The other thing that comes up a lot is compliance with anti-discrimination laws. And a lot of folks find out that they have gotten bigger really quickly. And you can go for a number of years and really not need to be, or not have it directly be confronted by state or federal discrimination law, because things are going smoothly. You are, a thoughtful, courteous, professional employer. Things go well. And you really don't have to deal with this on a day-to-day basis, but suddenly something comes up and you're confronted with this area of the law that you really maybe haven't given much thought to, other than maybe posting the information that the state or the federal government requires of you. And the other thing that comes up a lot is issues with leave. And by that I mean, I'm going to term it very broadly. People who are away from your company for a particular reason and they're coming back. So these are kind of the common threads that I think most all small businesses have to deal with at one time or another. And when Sarah and Barbara were good enough to brainstorm with me about what we wanted to do, we didn't want to make it centric to just New Hampshire. So I'm not admitted in Vermont as a lawyer, but I did try to pull some examples from Vermont law that might be of help to folks who are Vermont employers who have a presence in Vermont. And I have to tell you, when I looked at some of the things that the state of Vermont is doing to make information available to people who are Vermont employers or have a Vermont presence, I was really impressed. I thought they did a very nice job of really synthesizing information for you. Let's get into some of the common problems. The first thing I would tell you, I think, is a big thing that you're going to see again and again is something real basic, the misclassification of salaried exempt people. And I've got some materials behind tab 1. So what do I mean by that? What I mean by it is that it really is driven more by federal law, the Federal Labor Standards Act, Fair Labor Standards Act. So that's really what we will see, that you're going to be confronted with, and it isn't contingent on how big or how small you are. So most of this stuff, if it's going to trip you up, is really going to be a creature of federal law. And what do we mean by misclassification? The federal law says that you have to pay people a minimum wage, the $7.25 an hour, and overtime if people work time over 40 in a work week. And so when we say salaried exempt, it's a big buzzword for the fact that you're not required to comply with those minimum wage and overtime laws if you meet those, if you have a position that falls in a salary exempt category. And that's where things kind of go off the rails. A lot of times we as business people have gotten into a bad habit of thinking that if somebody is salaried and it seems like their job title seems like it fits the bill, that means they're salaried exempt. That isn't really the case. What it means is that you have to be salaried to be salaried exempt. That kind of makes a little bit of sense. But beyond that, you need to be sure that the position in question is satisfying one of the exemptions. And so how do we go about doing it? It's fact intensive, and it's not based on what you call it. It's not based on, a nice job title. It's not based on the fact that you think somebody's an executive. It's not based on the fact that you think somebody is an administrative professional. It's really based on that position being able to meet all of the criteria that the U.S. Department of Labor has developed. So I don't know what this says about me, that I get excited about wage and hour fact sheets. I need to probably get some hobbies. But what I did was a really nice thing for you to use in your business owner tool chest is these great fact sheets that the U.S. Department of Labor has developed. And they have tried to put these concepts into some really plain language examples. And so behind tab 1, what I have for you is there are certain exemptions that could exist in your business. Executive, administrative, professional, maybe not so much for everybody, computer and outside sales employees. So just to let you know what you have here so that you can be using it going forward. There's a fact sheets that have been developed. They are relatively recent as far as government goes, within the last 10 years. And the first fact sheet that you're going to have gives you the overview of all of it. So really what you're probably going to be dealing with the most is whether or not somebody fits an executive exemption or an administrative exemption. And that's the first fact sheet. They have professional exemptions for people like lawyers, doctors, people who have advanced bodies of knowledge. And one thing you're going to see at the end of this first fact sheet is the highly compensated employees exemption. Now that's a real nice problem to have. If you've got an employee that's making that much money, you probably means you can pay them that much money. So you're probably doing pretty well. Just something to bear in mind. It doesn't really leap out at you, but we have gotten into a bad habit of kind of saying, okay, highly compensated employee, they satisfy the exemption. That's not really the case. They have to meet these other tests. So in addition to being paid $100,000 or more a year, they have to fit within one of these other criteria. What I have next is you're going to see the test for executive employees, and administrative employees follows after that. One of the things that you're going to be seeing in these tests is that you're looking at the primary duty of these people. So again, just to beat this a little, beat the drum here a little bit further, it isn't what they're called. The job description, one thing that you can be doing that can be real helpful is when you're developing your job descriptions, sit down with these fact sheets and figure out what factors that you think are set forth in this person is going to be doing. And what's really nice with the executive and the administrative exemption in particular is you see some examples. They have some great examples about, hey, this is what we mean by primary duty. This is what we mean by having some discretion and control. This is what we mean by supervising 2 or more employees, which you have to do for the executive exemption. And as you sit there and develop your job descriptions, you can weave right into them, assuming it's true, some of these concepts. I think that will be helpful to you. The other thing that you can do is they actually have to be doing it. So you can do all the job descriptions in the world that you want, and it's really going to come down to what is the person actually doing. So for instance, one thing that you can be doing as business owners, in part of your due diligence and reviewing your business practices is when you look at job descriptions, look at them with a bit of a fresh eye and say, is this person really doing this anymore? Have this person ever done this? Do we need to revamp the job description a little bit to reflect, what's actually happening here? So I think probably universally in the room, probably the fact sheets that you will use most are the ones for the administrative and the executive exemption. And I really encourage you to take a good look at it. It's great examples. They can really help you decide whether somebody should be salaried exempt or not. You're going to see professional employees exemptions in there, which may apply to you or to your employees, some of them or a few of them. You're also going to see some of the other kind of more industry-specific examples, computer-related employees, and that's one to be careful about. It's interesting because you don't necessarily need to have a salary. You could pay the person by the hour, which seems a little counterintuitive. But be careful with that because it will give you some examples here. The people who are doing this exemption, if they're in your organization, they really need to be kind of high level in terms of their analysis. Computer analysts, computer systems programmers. And it is not to minimize the importance of the work that your IT people do for you, but just be careful that you don't just equate, hey, somebody has an IT function with this exemption. And you'll also see some examples for outside sales and the like. So these are just some great examples for you to take a look at, and I really encourage you to do. Just to give you the overview too, all of these fact sheets are backed up by regulations that the US DOL has developed, and very easy to find, 29 CFR 541, something like that. It's in these materials. I believe it's 541. And they give you great examples too. So to the extent that you're sitting here thinking, I'm doing this, I'm trying to figure out if this person's salaried exempt, I'm not sure, what do I do? You can go and you can look at those regs, and they're not awful. They're not they're not fun reading. You wouldn't do it for the fun of it or recreational, but they will give you some help. So that's the biggest thing I think I could leave you with in terms of some help for you if you're looking at salaried exempt. Now, what are the consequences if you get it wrong? Well, they're pretty major, because what you can find is that you had somebody that you thought was salaried exempt, and they're working crazy hours for you, and you're working crazy hours too because you're a business owner and you're working nights, weekends. But you were not thinking that you would have to pay this person overtime. And then you find out the hard way, oops, I got it wrong. Now, if you got it wrong and you weren't acting in bad faith, there's a 2-year look back as to try to recapture that overtime. And I'm assuming everybody's going to get paid a minimum wage, so that's really not how these things happen. If if you sat there and you were a scofflaw and you knew you should have been paying the person overtime and you didn't, the look back is 3 years. So suddenly when you think about these folks that are working real hard for you and working well beyond 40 week in, week out, that becomes kind of a big deal, to put it mildly. Yes?
What about the other situation where you have a salaried, an exempt employee, a professional employee, and can you set a minimum number of hours? Because we've had employees who would come in for an hour and something would happen and they'd leave and they wouldn't even work a minimum of 30 hours and they were expecting to get paid their weekly salary.
Yeah.
He set up a policy that said you have to work a minimum number of hours if you're a salaried professional to try to counter that, and I was just wondering what the law said about that.
Sure. Did everybody hear the question okay? You raise a couple of really good issues that could be implicated by that. I think first of all, you definitely have the right to communicate to your employees your expectations. And you touched upon the fact that when you're salaried exempt, that by definition means that you're paid the same regardless of the quality or, to your point, the quantity of the work. So what I have told, so I think it's perfectly appropriate that you, in sitting down with somebody, say, this is the expectation is that this job is a 40-hour-a-week job. There's going to be weeks when you work less than that. There's going to be weeks when you work more than that. This is the salary that you're going to get paid. What I have really said to people, and I recognize you weren't even raising this issue as an option, I have routinely said to people who are frustrated by that kind of situation where somebody rolls in and works 2 hours and acts like they're God's gift, and you're paying them the same amount as the person who's working 60 hours. To me, that's more of a performance / potential disciplinary action. I tell people, don't try to deduct from salary, because when you start to go down that road, you have state laws and you have the FLSA that has some really, really limited reasons that you can deduct from a salaried exempt employee's pay. So the thing to do there, my advice would be to nip it in the bud. And this is not our expectation. Chances are real good if they're doing that, they are not getting their job done. I mean, they're just, you're not going to get the same amount done in an hour that you're going to do in 40. So that's how I would handle it. I try to keep, it's a real problem, but it's a problem about work ethic and performance, and I would try to nip that in the bud as soon as anybody is able to, but not by, deducting from salary. If they turn around and say to you, okay, well, I only want to work so many hours, it's like, well, all right, you're saying this, maybe this works for us, maybe it doesn't, but we're not going to pay you for 40 hours if what you want is a 15-hour-a-week arrangement. So I would be renegotiating the salary at that point. The other common thread that we have is the big bugaboo for many folks is the misclassification of folks as independent contractors. And what I've put in the materials, just so that you have, is an article I wrote a couple years ago. It's still, conceptually, it still holds water in that the problems still remain the same. And what I did was I had updated some IRS materials for you that the IRS just revamped within the last month, not significantly changed in any way from what had existed at the time of my article. And I just like to talk with you about the concept of this a little bit and kind of how it's, the magnitude of it is significant, because this is not a one-stop shopping analysis. This is, you got to look in a lot of places analysis. And what we have seen is that I think probably 10 years ago, people here sitting in this room would know any number of people who were consultants. And that means that they were independent contractors. It was, you said one, it meant the other. That person was fine with it. The company who they were consulting with was fine with it. It was all great. And what has happened since then is that the federal government and the state governments have really, particularly in the last 5 years, absolutely cracked down on this. And the reason why is because if you're doing that, if you're treating somebody as an independent contractor, they're not getting a lot of the protections of the law. They're not getting workers' comp coverage, they're not getting taxes taken out, they're not getting unemployment taken out, they are not subject to some of the discrimination laws we're going to talk about. And how things really go badly is never when it's all going well and everybody's happy with the arrangement. It's when something goes wrong. Somebody doesn't get re-engaged for the next project. Somebody gets hurt. And when you get hurt and you don't have insurance of your own, or if you do, you say, it's pretty easy to say, I thought I was the employee. And it doesn't do you any good as the company to be saying, well, hey, we were all good with this. So these situations are really becoming absolutely a cost of doing business at this point for a lot of people, but the consequences are very big. So when I say, what do I mean by the whole independent contractor analysis not being one-stop shopping? What I have for you is some citations to our New Hampshire law in my article. And again, that is just to get you keyed into that law so you can go look it up if you ever come into this situation, and don't, make sure you're always looking up the law as it currently stands and not relying on something that, maybe a year from now we were talking about today. But you have the citations to that. This concept is multifaceted. So when you're sitting there trying to think, is somebody an independent contractor or not? If there's one takeaway I could give you, I want you to assume that they're not going to be until you can establish for yourself, to your satisfaction, or sit with your accountant or sit with your lawyer and establish that they are. Because the presumption really is going to be that somebody's an employee until you can prove otherwise. So what are some of the tests? We've all heard of the IRS 20-point test. Now what they've done with that, and you're going to see it in the materials I gave you, is they have really kind of tried to put things in 3 buckets. And so what I did, just so that you'd have it on hand, is try to compile for you the IRS kind of helpful guidance about what they mean about being an independent contractor. And they divide it into looking at behavioral issues, financial issues, and types of relationships. And you're going to see all of that in your materials, and you can look at that at your leisure. But it doesn't stop there. And there are some very different tests that can happen under state law. In addition to the IRS, before I get to state law, I also gave you another fact sheet from our buddies at the USDOL that talks about what, for wage and hour purposes, the USDOL would consider to be an employee or an independent contractor. That you're going to see that's not the same as what the IRS is saying. There's a lot of overlap in terms of the kind of things you're looking at, but it's not the same. The other thing that I've left you with is this concept of how Vermont has developed this, which is real helpful because it actually is really very much a similar analysis to what you'd see in New Hampshire. And if you're talking about unemployment, there's another test there. And many of you may have heard of the ABC test. There's 3 factors, and you're going to see it in these materials I have from Vermont, which is just a really broad brush overview. But it's great because it really lays it out there for you at a glance as to what this so-called ABC test is. And you have to meet all of the factors. New Hampshire has the same test. And I would tell you that this is probably the toughest test of all of them. When you look at workers' compensation under New Hampshire or Vermont law, you're going to see a different test. And you're going to see that in the Vermont materials that I have for you. So the takeaway here is that please start your analysis with thinking, this person isn't an independent contractor. I'm going to have to pay them as an employee unless I can prove otherwise, unless I can look at all these tests, whatever is applicable to me, and satisfy them all. And you may be able to. I mean, it happens. There are people, the great example is a plumber. You know, you're working, you're running a law firm, you're running a design company. You don't do plumbing. You know, your sink breaks down, you call in the plumber. And he or she has a business of his own or her own. They hold themselves out as business. They're doing something that you don't do. There's all sorts of great examples where nobody would question somebody's an independent contractor. But when you're getting yourself into a business relationship that's ongoing with somebody, really do take the time to figure this out. Do take the time to verify these factors to your satisfaction. And one thing I've said in my article is be cautious, but be prepared to be creative. Because a lot of times when I talk to folks, and believe me, in the last 5 years, people are really catching on to the fact that, reluctantly, this person isn't an independent contractor. But when I talk to people and say, well, you know, why do you want them to be? The answer is, well, I don't want to pay them this, or I don't want to have them do that, or I don't want to offer them this. There may be many ways you can go about doing that and still be, you know, have them be an employee and appropriately classified. So you may find as you draw back, your real problem isn't that you really wanted to make them an independent contractor. Your real issue is that you had some concerns about kind of the compensation structure. And there's plenty of ways to work around that. The next big thing that has been going on as of late is, behind tab 3, is this notion of unpaid internships. And that has been huge. There are people, lawyers in the Southern District of New York who are, you know, vacationing in the Hamptons because they have brought these class actions about unpaid internships. And you're seeing it with the magazines, the high-level magazines. And I always think of, you know, The Devil Wore Prada. I mean, it's kind of that kind of environment. You're seeing it with Major League Baseball. You're seeing it with movie companies. You know, the movie The Black Swan is tied up in litigation right now because of unpaid internships. So what my little article is about is just because it's really focused on the private sector for-profit group. Now, if you're public sector, if you're not-for-profit, I haven't tried to address that here, but there are separate standards, and you may be able to navigate those to have unpaid internships. There's a greater ability to do that. But for us folks who are running businesses in the private for-profit sector, it is increasingly difficult to have an unpaid internship. It's not to say that you can't have an intern and pay that person minimum wage, you know, whatever the bare minimum you can pay, $7.25 an hour. You can do that all day long. That's not the problem. What the USDOL is really concerned about is these folks are getting paid a pittance or nothing at all. So you're not paying somebody minimum wage. So what are we looking at for considerations for unpaid internships? What you have to do is yet another one of the fact sheets from the USDOL. You have to satisfy this fact sheet number 71. And I've got that in your materials. It's right there for you to take a look at. And it's 6 factors. You have to satisfy all of them. And here, some things just to be thinking about before you kind of get into that bug dust is just the 30,000-foot viewpoint is that an internship really needs to be for the benefit of the intern and not for you. So if somebody is your intern and they are making copies for you and they're organizing things for you and they're doing all sorts of stuff for you and you're very appreciative and they're very appreciative because it helps their resume that they have been in your organization, guess what? They're doing stuff for your benefit and not for theirs. A colleague of mine who was doing a presentation on this May gave a great example of how he likened this to his wife saying to him, hey, why don't you have their college-age son, why doesn't Chris help you, paint the basement? And he's like, now I've taken something that's going to take me 2 hours and we've expanded it into 5 because, it's going to be more of a hassle. Little analogy where if you have an internship that truly is for the intern's benefit, it's probably a hassle for you. It's probably not really helping you out all that much because that person is shadowing you, and you might have them do things that are furtherance of their educational objectives, but they're really not terribly useful to you. But it really is for that purpose, that person's betterment. So if you're having them do a lot of administrative clerical things, chances are real good that's not going to fly under the 6-factor test. The other thing that you need to bear in mind is that people routinely forget, in New Hampshire at least, there is a requirement that you get this blessed by the New Hampshire Department of Labor, and that is pre-approved by the New Hampshire Department of Labor. I was real pleased to find on a board I was on, going through this drill myself and kind of thinking, wondering how long it would really take to have that pre-approval given. And if you do, if you fill out your materials appropriately, it was very speedily done. So I don't think you need to really worry about, gosh, if I do that, it's going to take forever. I have this person coming. Obviously, you want to do it sooner rather than later. But what I've given you is the statute for New Hampshire and a form for New Hampshire just to take a look at. And there's also some regulations in the New Hampshire Department of Labor website. So that's just a couple of big things to bear in mind as to the internship piece. It will not matter. You are going to be fine, at least as to wage and hour stuff, if you pay the person $7.25 an hour. You do that, this is irrelevant. But if you're thinking that you're going to have an unpaid internship or anything less than the minimum wage, you really need to make sure that you're fitting these criteria. The next kind of, one thing I will confess, I don't have a watch on, so if somebody gives me the high sign, if I'm taking too long, just let me know. We lawyers sometimes talk a little bit too much. The next big bucket of things I'd like to talk with you about is the anti-discrimination law. And I have in the materials something that all I wanted to give you is a real quick overview of what kind of laws you need to be thinking about. And there's a great little 2-pager about what laws are enforced by the Equal Employment Opportunity Commission, which is a federal commission out there that enforces federal anti-discrimination law. And it's a great just cheat sheet for you to take a look at. It talks about Title VII, which has a category of protected classes, and that's the buzzword for these things. If you have a class in one of these statutes, it could be gender, could be national origin, could be age. It's what the lawyers call protected classes. So if you could bear in mind that different laws apply to different things. So you have Title VII, which has been around for a long time now. You got the Pregnancy Discrimination Act, which is subsumed by that, the Equal Pay Act, the Age Discrimination in Employment Act, which is for people over 40, and Title I of the Americans with Disabilities Act. The Americans with Disabilities Act is pretty multifaceted, but Title I is what we all need to worry about for employment. And the Rehabilitation Act probably won't affect too many of us, and the Genetic Information and Non-Discrimination Act. So that's just a quick 30,000-foot viewpoint of what you need to be worried about, or some things you need to be worried about from the federal government standpoint. And why I say this is, just like what I said at the outset, many employers, they start out with one person or two people. And in most instances, you're not going to be covered by discrimination laws. You might, philosophically, I'm sure nobody in this room is going to discriminate against somebody, but you're not necessarily obligated to follow the law. And the next thing you know, you got 7 employees. Okay, there you're subject to the New Hampshire law. And next thing you know, you got 21 employees. Then you're subject to the age discrimination law in the federal law. You're subject to Title VII, which is gender discrimination, racial discrimination, and national origin. So suddenly, you've grown bigger, and you're held to higher standards. I'm leaving out the FMLA for this group, but that's, as we know, 50 employees. So just some things to be thinking about. And what will happen is that these laws have some corollaries under state law, both in New Hampshire and in Vermont. And so what I've given you is just a little sampling of some of the information under both states. I gave you some great examples as to how New Hampshire would deal with an issue of pregnancy discrimination, which is covered, considered a form of gender discrimination. And I also gave you some examples of Vermont's statute, which is broader than New Hampshire's actually. It has some categories we don't. So if you have a presence in both states, if somebody's working in Vermont, you need to comply with the Vermont law. You need to comply with the federal law, assuming that you are covered by it. It's certainly not a bad thing to know about, so that your practices, if you ever do get bigger, you're going to be well served to know about these as you grow. But so that's just something to bear in mind at the outset, just to really be mindful of your size and be thinking, wow, I just crossed the border into, now I'm subject to these discrimination laws. Again, for this group, it's preaching to the choir, but it's just good to know. I like another big thing I like to leave you with is the concept of retaliation. And I have not, in these materials, remotely tried to touch upon every type of law out there that affects you as a small business that deals with anti-retaliation, because they are all over the place. I mean that in that there are a lot of laws that affect you as business that built into those laws prohibit you from retaliating against somebody that has done something that is protected by those laws. So another takeaway from today, always kind of be on your guard about potential retaliation claims. And there's some important things to think about there. And what I did was, just to give you kind of a taste of the concept of retaliation, behind tab 5, I gave you what the EEOC would consider to be retaliation. And it talks about that, and then it gives some great examples about facts about retaliation. Now this, when I say the EEOC, the beauty of employment law, I'm saying that sarcastically, is that we have acronyms for everything. I mean, it's alphabet soup. But the EEOC, again, is the agency that enforces these discrimination laws on a federal level. And this is really helpful to you about facts about retaliation. It applies just to the EEOC's guidance, but the concepts really hold true kind of generically for other situations you might find yourself in. For instance, there's a lot of laws we have a whistleblowers protection statute in New Hampshire. Many laws out there have whistleblower or anti-retaliation provisions like I talked about. But what does that mean? What does retaliation mean? It could mean that obviously, if you fire somebody or suspend them or demote them, but maybe it's because you gave them an unfavorable assignment. Maybe it's because somebody says she knew I really needed to work those hours. I complained about fill in the blank, and the next thing I know, my hours got changed. Now I have to work the night shift. I think that was in retaliation for me doing something that's protected. What do we mean about protected activity? Now, obviously, if somebody sues you over something that is within these discrimination laws, that's going to be protected. It seems ironic, but somebody could, you could be going to a deposition with an employee, and then you all come back to work, and how much fun is that? But you can't fire them if they are. It would be ill-advised to fire them if they are engaged in a lawsuit with you. But there's lots of other things that aren't quite as obvious, which are the fact that they could be participating in an investigation. So I think we would all kind of understand that Sue complained to you that she had been picked upon on account of her age, and you investigated it. And in investigating it, you talked to Barb. Well, Barb didn't have any complaint. She didn't think that anything bad had happened to her. She wasn't bringing a complaint forward to you. but she participated in this investigation. She is protected. She could say, gee, you know, you asked me what I thought, or you had somebody come in and investigate this, and I told them what I thought, and the next thing I know, I'm being demoted. You must not have liked what I had to say. So just be mindful, it's not as obvious as it would seem as to who is protected. And the other things it can be associational as well. So by that I mean, you know, many businesses in New Hampshire and Vermont, you could be the biggest business in your community, or you could be a significant business owner in that community, and you can hire family members, or you can hire people who are, you know, husband, wife, mother, daughter, and fiance, and that person who didn't have the gripe themselves is saying, you did something to me because my mom, my dad, my fiance complained to you. So with retaliation, bear that in mind. The other big thing is timing. Timing's a big, big deal, because it isn't to say that you can't run your business and you can't address people appropriately if they are not doing what they need to do. But just bear in mind, you know, when it comes immediately on the heels of somebody doing something that's protected, that person may be arguing, there's a connection. There's, you know, I did this, then this happened to me. And so you really need to be able to explain and show why no, there isn't a connection. The timing isn't great, and we're not crazy about the timing, but this person's performance review was already prepared, they already had these problems, and the day before we were to give it, they came in and they complained about this. And we see this happening a lot with, not to be a cynic, but we see this a lot with people who complain during their performance review. Things aren't going too well, and then something comes up magically during that time frame. So it isn't to say you can't do what you need to do as a business owner, just be mindful of these concepts. And when you're seeing these things arise, think, okay, is there something I could be doing to address this situation that I'm concerned about concerning the employee? And do it in a way that wouldn't make anybody think I'm retaliating against them. And I'm not saying you pull a fast one, but you know, you're not intending to retaliate. You have a problem you have to deal with. Is there a way to deal with this in such a way that I can work through this and not really have anybody have an argument to make that I'm retaliating? Example, you know, instead of a written warning, the person gets counseling. This isn't disciplinary, this is just to let you know our expectations, that sort of thing. The other items to talk about, traps for the unwary, are I'm going to just talk about these generically, and within your materials I have both the Vermont Parental Family and Short-Term Family Leave, which is a really great, well-developed leave law in Vermont, and New Hampshire's Crime Victims Employment Leave. So I have both of those materials right in there, the statutes for you to take a peek at. First of all, the reinstatement piece. A big trap for a lot of folks is that there are laws out there that apply to you that give people a right of reinstatement. Workers' comp. People have a right to come back to their job if they've been out on a workers' comp injury. And that, in New Hampshire, that right is 18 months from the date of injury. Family and medical leave, we're going to leave that aside for now, but that's a great example of, if you're a bigger employer, there's a right to reinstatement built right in that law. The thing I'd like to leave you with is that a lot of employers kind of look at it in a very linear fashion, which is, it says that this right of reinstatement ends. Okay, it has ended. Now today I can terminate that person. And I've dealt with employers that have said, FMLA runs out on August 28. When that person gets back, you know, I'm going to terminate them on August 29. And I said in my materials, this is a great example of what you can do is a lot different than what you should do. And just because you can doesn't mean you should. What will happen when you do something that is adverse to an employee right on the heels of them being done with a reinstatement right is them saying, you're retaliating against me. So that's that timing issue I talked about just a minute ago. The other thing is, another trap for the unwary is when people are coming back to work. A lot of times we will deal with employers who are, there can be a level of frustration. The person's been out for a long time. Maybe you've been going back and forth with them about when they expect to be back. You had an expectation they were going to be back at a particular time, and then they contact you and say, I'm going to need another 10 days out. And there's a lot of kind of a visceral reaction of like, enough already. God, you've been out forever. Enough's enough. No, you're not. No, we're not going to let you do that. You said you were going to be back. You can't be back. This is a problem. Just be careful about that, because one thing that is easy to forget about when you're dealing with the workers' comp and you might be dealing with protected leave is that out there is the ADA, if you're big enough, and the state discrimination law if you're smaller. And one thing that people forget is that allowing somebody a little more time off, within reason, could be a reasonable accommodation. That's what they need. I could perform my job if you give me another week off. And it's not for people trying to look for vacation. It's for people that truly are out, they had a need, they need just a little bit more time off, supported by a healthcare provider. And that, if it's within reason and you're able to do it and it's not an undue hardship, which is a big deal, it has to be a really big deal for you, that might be something that you need to work with them on, so that you're not accused of disability discrimination. So that's a trap for the unwary that a lot of people trip into, because they're not trying to be rude or callous. It's just something has kind of gone on for a long time. The last things I'd like to leave you with, just to go over very quickly, are some recent traps for the unwary. And I will say that these are New Hampshire oriented, so thanks for the folks in Vermont. Have a little patience with me here. We have a new pay equity law in New Hampshire. I gave you an article written by a colleague of mine. And one of the things that it provides that is of interest, and it really does kind of reflect where the National Labor Relations Board has been going on this topic, is that you can't forbid somebody from talking about their own pay to other people. And in a lot of handbooks, it wasn't because people were trying to be, tyrannical, but they kind of considered this information confidential as an employer. And a lot of handbooks say this is confidential information. You're not supposed to talk about confidential information. The National Labor Relations Board has really been cracking down on that, because they view it like people need to talk to one another to kind of commiserate and learn more from one another if they're trying to organize a union. But in New Hampshire, that has now been built into our Equal Pay Act law, which is going to go into effect in January. So that's something that is on its way, just something to bear in mind. So people can talk to one another, and you'll see in the law there's some carve-outs for people who are HR people that need to deal with this type of information day in, day out. The next thing that I have for New Hampshire folks, but I just want to kind of give you some concepts that could help you no matter where you are, is a revision to this really difficult law about non-competes. And why I say that is because, excuse me, not because it's a bad law, but as this law came out, I want to say a year ago, and it kind of took everybody by surprise, because what was happening, excuse me, I can feel a cough coming on, so I apologize. What was happening was the law wasn't really written very well, and everybody was kind of scratching their heads and saying, what do they mean by this? So in New Hampshire now, there's a law, and I've got it in the materials, that talks about what you need to do if you're giving somebody a true non-compete. And a true non-compete means I am telling you, I'm having you come to work for me, and you can't compete with me. You can't go to one of my competitors for a particular period of time after you leave. That is different than saying you can't take my customers, you can't take my confidential information. So that law is out there. I'm sorry. And what it provides is really something that I would recommend for you to do if you're going to do these types of agreements with people anyway. We generally say a non-compete is a lot harder to enforce than asking somebody not to take away your confidential information or your customers. So we really try to steer away from non-competes. But that being said, what this law says is you need to give it to the person and have them take it into account before you don't put it in front of them and saying, sign on the dotted line, and I'll sit here and look at my watch while you do it. You need to give them the chance to review it carefully and give them a fair chance and not spring it on them once they work for you. That's something we've always said that you want to do. So if you're in a situation where you are working with your attorney, and I would say work with your attorney to develop these types of agreements, talk with them too about what we need to do in working with our applicants, working with the people who we're going to have relationships with, to give them these materials before they come on board and have them have a chance to look at them carefully and consider them carefully so that they don't say, geez, I didn't have a choice. I was already there and they're giving me these materials. Or I felt like I was under duress. I felt like I had no choice. We do have a couple of new things. There is a protection from domestic violence discrimination statute that is of very recent vintage. You're going to see that behind tab 9. And that, as you see, is really only about a month old. And lastly, we have social media and electronic mail. Then that's a month old today. And that's in New Hampshire. And where this is going is that employers were probably doing a little more than they should, which is some employers asking people to give them their passwords, give them information so that they could look at the person's Facebook, the person's social media accounts. It feels like it's overreaching, and the legislature, at least in New Hampshire, says it is overreaching, and there's been a lot of concern statewide about that in different states and on the federal level. So that's not something you want to do, and in any event, we've always said that's not something you probably want to do, because even if you could, because you're going to find out way more about somebody than you ever wanted to know, and all you care about is whether they can do the job. So this is a huge 30,000-foot overview. It looks like we're running out of time, and I thank you very much for your attention. I know that we've touched upon a lot of things. I'm going to be here afterward if you would like to talk. I just wanted, and I hope that this will be helpful for you as you go forward and deal with these situations as you enjoy the challenges of being successful business people. So thank you.